SJC-13341, Commonwealth v. Jonathan Gandia.
Good morning. May it please the court. Michael Locke for the Commonwealth. The Commonwealth asked this court to either remand or reverse the motion judge's order requiring the Commonwealth to disclose the identity of the confidential informant that was involved in this case. First, at least a remand is required because the motion judge failed to appropriately analyze the defendant's motion according to the two-stage process that this court reiterated in Commonwealth v. DM. As the court knows, in DM, this court held that it's an abuse of discretion for a motion judge when analyzing this type of motion to either or both not take into account the stage of the proceeding at which the motion was brought, as the defendant has a higher burden at pretrial versus at the trial proper. And two, the motion judge didn't also fail to engage in the actual two-stage process outlined in DM. Here, the motion was brought pretrial long before the trial proper, and as the Commonwealth sets out in its brief and the court knows, there's long been maintained a difference between a defendant's request for the ID of a confidential informant before trial rather than at the trial proper. And again, here the motion judge abused discretion because she did not cite to DM, she did not cite to Bonnet, which came from this court a few years before that, and she made no mention of the stage of proceedings at which the defendant brought this motion and did not discuss the defendant's higher burden at this stage. For these reasons, at least a remand is required. The Commonwealth would further ask the court not to remand, to actually reverse the motion judge's order, because based on the facts before the motion judge, as a matter of law, the motion should be denied. Here, the CI was not a recipient witness to the crime that was charged here. The Commonwealth charged the defendant with possession with intent to distribute, not based on any of the transactions that the CI relayed to police. He was charged with possession with intent to distribute based on the cocaine and the money that was found on his person and in the vehicle after he was lawfully arrested for.
Along those lines, let me ask you whether remand is the better decision, because what you say is true. It was what was found in the fanny pack?
Correct.
22 grams?
Correct.
The defendant might argue that, putting aside how the informant could help on this issue for a moment, the defendant might argue that, sure, he wasn't a recipient witness to the search of the fanny pack, but the informant is the one that says, oh, a sale just took place, and he's leaving. And the fact that a sale just took place is really important and probative on the issue of intent versus personal use. So why isn't a remand better?
Because here, the Commonwealth, the CI would not be testifying at trial, so that evidence wouldn't even come in, that the CI had seen these prior transactions. The Commonwealth is going to proceed on the theory just based on the amount of cocaine.
Oh, but the defendant there's a compulsory process clause, not just a confrontation clause that we sometimes forget about. And the defendant has a right to put on a case. And maybe they want to call the, maybe not recipient witness to the search, but what's going on contemporaneously, which goes to the state of mind of the defendant as to whether there was an intent to sell or whether actually it was for personal use. And I recognize I'm putting aside the expected testimony of the informant, but saying not a recipient witness, technically it's correct, but the informant is right there as it's happening.
Right, but again, the arrest was lawful based off of the operating without a license. The defendant was not arrested based on.
I'm not talking about search and seizure issues. I'm talking about the defendant wanting to call somebody who is right there that is probative as it relates to state of mind, as to intent versus personal use. And again, I'm putting aside the expected testimony.
I would suggest, Your Honor, the defendant I think, based on the facts and the defendant's argument here, the defendant has not carried his burden to even establish that
Wouldn't that be the case if you were dumb enough to charge him with possession, with distribution of B, and you weren't?
Correct. The defendant would have a much better argument if he was charged with the actual distribution here, which he was not.
How do we know that the Commonwealth has properly asserted the informant privilege in the record?
I believe I submitted a motion to include the transcripts. I believe this was a 211-3,
Okay.
and I did not file the transcripts with the 211-3 petition, but once it was reserved and reported by the single justice, I included a motion to include the transcripts of this hearing. And at the hearing, the Commonwealth asserted the privilege and asserted that the CI's safety was in danger and that it would chill the further CIs from cooperating with the Commonwealth if the motion were allowed.
And just remind me that motion is still pending?
I believe so, Your Honor.
Okay.
I suppose I'll go back to here. The defendant can't establish that the CI's identity is material to his defense at trial. And again, we have to look at this in the context of that this motion was brought far before trial, before even a motion to suppress. And part of the issue when these motions are brought so early is that the motion judge had no real basis to make factual findings or credibility determinations. The motion judge was acting on this motion having only the police report in front of her, which again, I would argue is part of the reason why the defendant has a heightened burden so early, because we don't really know where this case is going at, and the motion judge doesn't really know where this case is going at. For all we know, the drugs and the money found here might be suppressed at a motion to suppress, and the CI issue becomes moot because the case is going to be dismissed because there's no more contraband that the Commonwealth can put forward at trial. And here, the defendant has tried to, I suppose this kind of goes to Justice Lowy's question, has tried to manufacture materiality here by asserting that he would call the CI at trial to testify that there was no actual transactions here. I would just state that that's entirely speculative, and it's entirely contrary to what the record that the judge had before her, which is only the police report, where the police report states that the CI told officers that he had been witnessing the defendant engage in drug transactions.
Yeah, so I understand that the two-stage Bonet process wasn't followed. I just want to, again, I'm just trying to figure out the remand or don't remand issue. So if this goes to trial, presumably the officers would testify as to individuals going up to the defendant and leaving quickly. The inference that they'd want to leave for the jury is that those were sales. And the informant's a precipient witness to that, and the defendant, I think, would make the argument that since the informant was right there, that they'd be able to speak to that. And I understand 22 grams is a tough argument that it's for personal use and not intent, but that doesn't mean that they don't have a right to present their side of the story.
Right, and I think this is the tension that we have where the Commonwealth has this privilege, and the defendant here has not satisfied his burden in establishing that he has a right to this information. I think just simply asserting, actually, there were no deals here is enough for the Commonwealth to have to give up this information. And
Well, that's the stage 2 balance.
right,
I mean, okay, but that as you point out, that whole process didn't occur.
right. I think based on the facts before this court is in the same exact position as the motion judge was, and I think this court can reverse based on having the police report in front of them. That's the exact same, that's all the motion judge had in front of her. And I would assert that here the defendant has not met his burden, especially at such an early stage. Finally, just a few things. First, the Commonwealth would object to, in his brief, the defendant moves to join his case with the brief in the next case under Rule 16. Rule 16 only covers cases where there's more than one appellee or appellant in the case and they join their briefs, so the Commonwealth would object to that motion. And I would just say Here, when these type of decision or motions are allowed, the Commonwealth is severely prejudiced, particularly here where the analysis isn't followed. Because here, once this motion is allowed, the Commonwealth now has to decide whether to file a 211-3, where this court has said that the court will not take every 211-3 regarding a CI issue, or the Commonwealth ends up dismissing these cases because we know that this puts the CIs in danger when we have to turn over the information to them. So I would ask the court to reemphasize the importance of engaging in this two-step analysis. If there are no further questions, I would rest on my brief.
Thank you. Okay. Attorney Schneiderman.
Good morning. Good morning. May it please the court. I am Joseph Schneiderman. I represent Jonathan Gandia. I think Your Honor, Justice Lowy actually hit the nail on the head as to why disclosure was proper in this case, because the confidential informant was right there, was the only non-percipient government, was the only percipient, backwards, only percipient non-government witness, and that credibility of that witness is the heart of any defense at trial.
This is just a routine case. The rules of the road, as I think I understood them, would be if the government is stupid enough to charge distribution of B, and there's controlled buys, for instance. So, hypothetical case, there's a series of controlled buys with an informant. You've seen 1,000 of these cases. They execute a search warrant. They find, 16 grams, and the dispute is personal use versus distribution use or distribution amount. We've never authorized discovery or to breach the informant privilege for the controlled buys, right? Because they charge them with possession with intent to distribute. So why is this case different from the routine case that we always see?
Your Honor, what I think is different, or what this court has reaffirmed in the last 5 years, is the breadth of the Commonwealth's discovery obligations. But for the fact that the informant is involved, any information that the informant might have.
But this is the one sliver the Commonwealth has where you have to show something.
I appreciate that, Your Honor, that the defendant does have to show something. And here, I would suggest that the defendant can't be held to anything heavier than what he has. This is occurring right early in the case. All the defendant has is a police report. The defendant doesn't have anything further. I mean, the police report, which is reproduced in the record appendix at record.
We agree with you on this case. We get the hypothetical case I just talked about with the controlled buys, and you say, well, it's going to be relevant as to whether or not this person's telling the truth. We want discovery. It's every case if there's no standard, correct?
It may be every case, Your Honor, but then the defendant would still have to meet a burden, and I would suggest that here the defendant did meet their burden based on what they had, and to suggest otherwise would be to hold the defendant to an unrealistic burden. The defendant here just had the police report. The police report at record 15 says the CRI has engaged in left a warrant, but there's nothing else. Captain Keenan at the Springfield Police Department knows who this CI is, but we don't have anything else to go on. There's no references to warrants, other cases, which information the Commonwealth could have provided when they opposed this motion to say, wait a minute, we have someone here who is indeed reliable and who we can believe in. The Commonwealth didn't do that. That actually goes to something I wanted to respond. Justice Wendland had asked about the invocation of the privilege. At transcript 6, the Commonwealth walks back through much of what is in the police report, but they don't articulate anything more concrete about this informant. Unlike, as Justice Gaziano, you might have been driving at, I don't want to put words in your mouth, DM, where in DM there was a history of gang involvement. Unlike Barry, where indeed a single justice of this court had to intervene to safeguard witnesses. The Commonwealth's invocation of the privilege, I would suggest, if it is fairly invoked, is tenuous at best, and I think the motion judge was alert to that.
So you don't oppose the motion to submit the transcript, because that seems to be the only place where this is asserted?
Not at all, Your Honor. That's best practice of single justice advocacy, is if you have a transcript, bring it to this court. So I do not oppose that in the slightest. I commend my brother, actually, for having the wherewithal to submit that. So assuming, though, Your Honor, yes.
No, I'm just saying, you're a frequent flyer. You would have submitted the transcript.
Absolutely, Your Honor. And I've said rule number 1 of single justice practice is to have an adequate record in this court 4 years ago. So yes, I absolutely would have. I do not oppose it at all. I commend my brother for that.
And we commend you for commending him.
Thank you. Commendations all around. Back to the merits, though. I think, though, this is the difference here, and this goes back to what Justice Lowy was asking my brother. The defendant can't know what he doesn't know. And at this juncture, all the defendant knows and has to go on is the word of Detective Aguirre and possibly also Captain Keenan. We don't have anything else beyond that. All we have is an informant. We don't have hand-to-hands going on at 49 School Street. We don't have that. We do have some repetitive behavior, but the difference between...
I guess, if the defendant doesn't know what the defendant doesn't know is enough to breach the privilege, then what isn't? That is, if it's enough for you to say, I don't know what I don't know, therefore tell me who the CI is. Is that what you're arguing the legal regime should be?
Not quite, Your Honor. I appreciate the point. I'm saying that based on the record he had, the very minimal record that he had.
Right, and based on what the government's asserting as the offenses charged. Go ahead.
Based on the offenses that are charged and the world of difference between possession with intent to distribute and straight possession, which is a felony as opposed to a misdemeanor, the difference is significant, the collateral consequences are significant, and all of that has factored in to the government, to the analysis under DM and Bonet, the nature of the crimes charged and what the possible defenses are. Discovery may actually foster further proceedings in this case. Indeed, discovery could lead to, as my brother hinted at perhaps, a motion to suppress. Discovery could lead to a disposition. We just don't know.
What we don't know, though...
Or dismissal, because they don't want to give up the informant.
That's quite possible too, Your Honor, yes. Your Honor.
Yeah, I guess the issue is that Bonet lays out a process. And after the Commonwealth has provided sufficient information, stage 1, the defendant has to come up with something. Something that they can argue to determine whether or not there's something there that the privilege should be set aside because it might interfere with the defense. If they establish that, then you go to balancing. You don't go right to balancing. And we didn't have that stage 1. And I'm not, when I say, it's a question, not an answer. When I say the informant's information being there at the scene when there's alleged hand-to-hands right before might be probative on the issue of intent, I'm asking the question of whether or not that satisfies stage 1, not what happens if it does when the judge goes to stage 2 and does the Bonet balancing. So I don't see anything on this record even close to affirmance. But I'm asking whether or not the process should be implemented that was supposed to be implemented with this a two-stage process in Bonet. And is there enough for stage 1 or not that this person, unlike most controlled buys, which particularly when they're not part of indictments, whether or not there's enough that it's a question, not an answer, that the informant was there. Does that satisfy, is that enough of a concern for a remand as it relates to stage 1? And then presumably you'd go to, if the answer were yes, you'd go to stage 2 and see what happens with the balancing. I don't see any route to affirmance here.
Your Honor, as I opened with, it's not just that the informant was there. He's the only person, or they are, I'm sorry, because we don't know the informant's gender. They are the only person who saw the drugs themselves. Yes, the police ultimately find drugs on Mr. Gandia, but the fact of the informant's presence, and I appreciate the point, presence could very much be overburdened, presence and observations, and indeed at record 15 into 16, the informant is saying Mr. Gandia is getting ready to leave. This informant was there in real time. The heart of this case is likely going to be credibility. Even if the Commonwealth doesn't want to call Mr. Gandia, we may want to, or I'm sorry, that's backwards. Even if the Commonwealth doesn't want to call the informant, Mr. Gandia still should have some opportunity to at least get into that and figure out if the informant is credible. So I think on that balance, Your Honor, the combination of it, the informant being there, witnessing the drugs, witnessing them going back and forth, all of that is just enough to satisfy stage one, and any further questions perhaps may be well suited for a remand. But I say we satisfied stage one, and the motion judge was alert to that. At addendum 170, she recognizes the salutary nature of the informant's privilege. She then says, I find, though, this is the problem with tabs. The court finds that it was the CRI who observed what he determined to be crack cocaine and a drug deal prior to the defendant's arrest that provided the requisite probable cause. The court finds that the CRI is essential to the defendant's defense. That should be enough, and any further questions should be left perhaps for a remand. But I think at this juncture, there was enough for the motion judge to order disclosure, and to hold otherwise would be to put the defendant at an extreme disadvantage to even be able to formulate and foster a defense. And that's his right, is to figure out strategically how to formulate and foster a defense. And indeed, even in Bonet, this court recognized that the ability to form a defense has to be solicitous. That's, I believe, at page 847 into 848 of Bonet 1, and that all stems from past decisions involving informants. In sum, Your Honors, I think there is just enough on this record for the motion judge to conclude that disclosure was necessary and appropriate, although the motion judge did not take the ideal course to show her work and walk through the sequential analysis in DM and Bonet. The order nevertheless remains sound because the informant was there, was the only non-government recipient witness, and would be the heart of it, even if the Commonwealth chooses never to call them. Unless Your Honors have further questions, I thank you for your time.